I am. Hello, good morning.
Good
Good afternoon,
morning.
wherever we are.
Yeah, wherever viewers are watching from or gonna watch from. So it's such an honor to have you as a co-host. So this is ADR Across the Globe podcast with Mr. Tony and myself, Dr. Chinwe. So I don't know if you have anything to say about what the podcast is all about. Maybe just a one-liner, Mr. Tony. Thank you.
ADR across the globe. It's looking at the whole range of ADR, ODR, digitisation, the process of enabling people to rid themselves of the burden of disputes.
Yeah, thank you so very much. And of course, with this podcast, we're trying to reach other countries as well to find out what's going on in their country, pertaining to ADR, pertaining to their court system. And particularly today, we're looking at the digitization of the court system. So we're looking at England and Wales for today. Probably we're going to look at some other continent or country in the next episode. So I'm just going to go ahead and introduce you. So Mr. Tony Guise, in different capacities, has been at the heart of every major civil justice reform of the past 30 years in England and Wales, and very much so active in recent years as well. And he now works full-time as the director of Dispute E-Filing Limited, an online dispute management platform and campaigns for civil justice reform. So you could check out his profile on LinkedIn. And then my own self, I'm the host of SPAC Views of ADR podcasts. So
Yeah.
So without further ado, can I stop sharing there?
Let's go.
Yeah.
Well, I'm delighted to be co-hosting this podcast series with you, Dr. Chinwe. It's an exciting new venture for me, and I think we're kicking off with one of the boldest, groundbreaking projects in the world at the moment, which is the digitization of the civil, family, and tribunals in England and Wales. So, what we've been doing since 2016 here is creating portals or platforms. The government has been doing this for different types of civil, family and tribunal claims. Progress has been made. We've got we have a foundation of a common core database, and the routes into that are different, so that the user sees different routes in, whether he or she or it has a claim for example, a fixed sum of money. That's something called online civil money claims, or if they have an unliquidated or unfixed claim for damages compensation, and that's called the damages claim portal. In addition to that, we have a platform produced by Thomson Reuters, outsourced to them, called Courts Electronic File, e-file for the higher courts, and the tribunals and family have their own systems. We've recently digitized the process of divorce and also made divorce no fault. So one can divorce without having to wait 5 years to be separated, for example, as it used to be in the old days. But this is what has been going on for the past 9 years.
Sorry, Mr. Tony, I just want to interrupt you. Can you just clarify? Is it just you mentioned the family court? So this digitization of the courts, it's like an all-rounder in all the courts in England and Wales, not like only criminal, courts.
I haven't mentioned criminal because that's outside my sphere of experience, but I can tell you that at the same time as this has been going on,
Oh, okay.
The criminal courts have also been digitising on something called Common Platform. So
Okay.
that is the case. So all the courts, you're right,
Mm.
all the
Mm.
courts have been digitising, and that programme came to an end in March 2025 after it had, I think, 2 extensions or 3
Mm.
extensions, something like that. It hasn't quite completed end to end yet, but it is getting there, and I'm sure in the next 2 or 3 years. The process will be end to end. So you issue your proceedings,
Yeah.
and then you end up in court with access to the papers, the bundle on the screen. So that is all good. Not content with that though. Sir Geoffrey Voss, the Master of the Rolls, head of civil justice, second most powerful judge in England and Wales, in charge of the civil courts, alongside the president of the family division, and also the senior president of tribunals, is working to digitise pre-action, or I think more quickly understood, pre-court. We have a system of pre-action protocols in England and Wales, which started under Lord Wolfe's inquiry, his recommendation in 1996, would you believe, his final report, and they came into being. There are now some 18 pre-action protocols. One is a practice direction, and the others are guidance, if you like, as to behaviour. And the idea, very big overview, the idea is that we digitise those so that people can work online, but even before they get to that stage, they find a way of a credible, reliable way of accessing the legal guidance, the advice they need to determine which is the best route for them. Is it perhaps a little confusing if you're not familiar with it, to be confronted with a number of different portals for different types of claim. So that's the idea. Even more groundbreaking is that pre-court phase will be delivered not by the government, because it hasn't got the money, but by a public-private sector collaboration. So that's companies like Mine, Disputesy, Filing.com Limited will provide a platform, and I'm also developing a new project with colleagues called Lyseon. We'll talk about that later. But that very broadly is what we're trying to achieve.
Thank you so very much, Mr. Tony. Would you give simplify what digitization is? So if the layman is watching, or they would understand what you're on about. Thank you.
Yeah. So you have a dispute, let's say, with me, and you wish to commence court proceedings. Once upon a time, you would have to get a paper form or type out a claim form and take it to the courthouse with a check for. I mean, when was the last time you used a check? I can't remember.
Myself as well.
I can't even find a checkbook anymore. And you'd have to take it down to the courthouse, hand it over the counter, and the nice lady or gentleman would then stamp it. And then you'd have to take that document round to me, and you would have to give that to me, and I'd then be duly served. Well, that's
a long process, is it?
Process. So that would take weeks, possibly, or some time anyway, 1 or 2 weeks. Now they've reduced the issuing process and, to a degree, the serving process to a digital platform, so that one logs on. You have a government account. You log on and you complete your details by typing them into a screen, into a template, and then that produces a claim for you. At the Civil National Business Centre, which is instant. You pay your claim fee with either a credit card, debit card, or if you're a lawyer, you have an account. So they debit the account, and every quarter, every month, they claim the money via a direct debit. Now, that then produces your claim form within seconds. or as long as it takes you to complete the form. Not very long. I've helped people do that, and it's been really interesting to see. It's a really good process. They've spent a lot of time on this, I know, but it does work, and it's impressive. So you do that, and then you serve it in accordance with the rules, which can be by first-class post, or in some cases you can serve by email. You have to follow the rules.
Okay, thank you so very much. I think I read somewhere that about the inclusion framework.
Yes.
Can you please elaborate?
Yes. Well,
on that?
this I mentioned earlier that we are the Geoffrey Voss, head of civil justice. His great project is to digitize not only the courts when you issue, but the period before you issue, pre-court, and also include within that a system whereby people can be guided or sent to the appropriate resources for their needs. So you mentioned the inclusion framework. That is part of a consultation being begun on the 11th of July 2025 by something called the Online Procedure Rule Committee, which not many people have heard of, but it is going to have a big effect. It is going to affect millions of people in the pre-court space, and its role, it has been agreed with government that its role will be to create a set of online rules for post-issue and pre-court for, to begin with, property and possessions, and also family financial remedies. But eventually it will cover the whole panoply of civil proceedings. Now, within this consultation, there are two parts. You mentioned the first part, which is the inclusion framework. And quite rightly, the Online Procedure Rule Committee and the government are keen to ensure that as many people can access this as possible. So those who have difficulty reading a screen, for example, because the font is too small, they will be supported by having a well-established tool whereby one can increase the size, the scale of the font. That's just one example. But there are many different ways in which inclusion can be delivered. And another focus is data and the measurement of that data. Online platforms produce data, they deal with data. And one of the big wins, if not the biggest win, from this project, the pre-court project, is to get a vision, being able to track the user's journey and his or her, its experience of that journey. So we're talking about qualitative and quantitative data being produced, which can then be analysed by independent researchers to say, has the inclusion framework included everybody it could? How many people
in Netherlands, they've done that as well, In Netherlands, they've done that as well. So
okay. Very interesting. I was at a book launch yesterday morning with Professor Sandra Kramer and Professor Masoud Ahmed. And we were they were talking about the Netherlands and the way in which it's digitizing its courts. So it's happening all over the world.
I'm going to talk about that maybe later.
Sure. So inclusion framework is intended to its purpose is to include as many as possible to support those who would otherwise be digitally detached, to enable those with disabilities nevertheless to be able to use the pre-court digital platforms, either, as I say, by adaptations, reasonable adaptations, for example, font scale, or having a page reader. These are all well-established technologies, but for the first time, the authorities are saying you must design in accordance with this standard. And eventually, rules will be prescribed. At the moment, it's proposed only to issue guidance, saying these sort of things should be done. But in 2 or 3 years' time, they will become rules once you've tried and tested how things go. And people have geared up their systems accordingly. They will become rules. And this will be to the great benefit of millions of people who are trapped in dealing with a dispute and want to resolve it speedily.
So, Mr. Tony, thank you so very much for this insightful projection on what and how far the digitization of the court system is going on in England and Wales. However, I think I was sort of itching to hear about funding, because I think we've mentioned this in the Jeremy Bentham episode about how funding has a very big poses a big challenge when it comes to reformation of the courts and in ADR as well. So can you sort of enlighten us about funding?
Of course. Well, I wish I could. The truth of the matter is that this is one of, I think, perhaps 2 or 3 big missing pieces from an otherwise brilliant public engagement exercise document. And it's on the Online Procedure Rule Committee pages. So just Google Online Procedure Rule Committee, and that will bring up that web page for you. You can scroll through it. The inclusion framework and the public engagement document is all there, but it is missing. There's nothing about funding, moreover, nothing about sustainability. It's one thing to start these things, you've got to keep them going. So in the disputes e-filings submission, we are addressing a number of omissions. One of them is funding, at the same time as we are proposing ways of addressing the funding problem. There are 2 other things going on in relation to this. One is an inquiry by the Justice Committee of the House of Commons, the UK Parliament, into access to justice, which includes looking at funding. How can you fund? How can you support people getting access to justice, getting the help they need? The other one, of course, is a Nuffield Foundation funded piece of research being undertaken by the Centre for Socio-Legal Studies at the University of Oxford, together with Professor Neil Rickman, who's, I'm proud to say, one of my colleagues in the Lyceon project, and the Access to Justice Foundation with Claire Carter and Martha Della Roche working there. And that is looking at mixed sources of funding. For example, saying to law firms, the interest that you earn on your client's account, let's see if we can't agree with the, for example, Solicitors Regulation Authority, that you can apply some of that interest, which can amount to millions of pounds with big firms. Part of that goes to fund, for example, Advice Now, a charity that develops resources that explain, and they're brilliant resources, that explain how you can exercise your rights, either in court or otherwise. And so that's some of the work that's going on about funding at the moment. Our proposal is for a justice infrastructure levy to enable the core infrastructure. For example, the sending engine that Sir Geoffrey Voss wants to send people to the right place. That could be very expensive to do. His view is that it's not going to be costly. I disagree. I think it could be very costly. And not every agency, for example, Advice Now, which he mentions as being one of the organisations that would sign up to the new approach. Not every organisation, not every law firm will have an IT department capable of creating these data standards. So a centralised resource, for example, Lyceon, to a sending engine, if you like, would be one of the things that we would say should be funded by a justice infrastructure levy. But this is not a novel idea of mine. That's not one of them anyway. Michael Gove's suggested it, you'll remember, in 2015, and it's been knocking about for a while. But people like Dr. Liz Curran are vocal about the need to do something. The talk in England and Wales, I'm sure it's not the case elsewhere. All we do is talk about brilliant ideas, and put them on the shelf, and we take them down, and here they are. A nice, brilliant, shiny idea. Let's talk about this one again. So I think there is a groundswell of energy and enthusiasm to make something happen. So the funding piece, you're right to raise it. It's a big missing piece from the public engagement exercise.
Yeah, because the other research I've conducted in Nigeria and of course in the US, you could find out that funding was just one of the major disadvantages raised, and it poses a serious challenge, especially to the dispute resolution center. At some point, the government parastatals, they would fund them at some point, and then at some point you could see they are left without any funding as well. They will stop funding them, and then they begin to struggle,
Yes.
So I knew that would be a very big challenge as well here in England and Wales, and I didn't see where funding was mentioned, so I was very particular about that. And then you mentioned liaison.
Liaison, Lyseon. Yeah.
I'm very curious. What is that?
Yes. What is
I know
Lyseon?
it has to do with this AI digital transformation, isn't it? So,
yes. Well, Lyseon is a Greek word which means solution.
Lyseon.
And the idea, it forms part of this pre-action piece. It is an attempt. It is an attempt by me, by Hugh Evans of the Advisors Toolbox, who has created brilliant technology to support advice agencies and their workers, and Peter Hornsby, who is a user experience specialist, worked for the Ministry of Defence amongst other government agencies over the years, and Professor Neil Rickman, who, as you know, is a professor of economics at the University of Surrey. And the four of us have developed a prototype of a sending engine. It was developed, we all came together during the course of 2024, and we landed at the Civil Justice Council National Forum, where Amy Shaw, very in the private office of the judiciary, very kindly arranged to allow us to showcase what was then called Auto Signpost, but now is Lyseon, at the Civil Justice Council, and this excited quite a lot of attention and garnered some support. And the idea is that people will log on to that, and it will, as a result of a very basic form of AI at the moment, it is called Forward Chaining Expert System, and it will then guide the user to describe his, her, or its particular problem, and will then say, these are some potential resources. Take the data you've inputted, transport it across to this firm of solicitors or this advice agency, and then see how they can help you. So rather like in England, we have something called the England and Wales, we have the National Health Service in the United Kingdom, in fact, and they digitized some years ago. In 2018, they created something called NHS 111, a telephone number one could call for help rather than going to a doctor in the first instance. And they put that online, NHS 111 online. That cost them in today's money about £780,000 to develop it. There's a cost of the service, but it's been hugely successful. I think it's a great template. You put your details in, and what they say about it, it does not diagnose. So we're not talking about a Briggs triage thing. What it does is it sends people to places where they can be diagnosed. And so that is Lyseon.
Lyseon. I'm so excited because, we've embraced digital transformation in England and Wales. You know why I'm so excited? Because that would automatically reduce the amount of waiting backlogs of cases as well, and thereafter you would say that that would enhance access to justice in England and Wales. So I'm pretty
Yes,
much excited
yes.
about that. Well
We
done. So that's
well, it isn't done yet, but it will be well done. I hope.
Lysion, and the
Lysion,
prototype before was the auto sign and post.
auto signpost, auto
Whoa,
signpost. Yeah,
awesome,
yeah, yeah.
awesome, incredible. Yeah, okay, so yeah, that reminds me, I think I read somewhere about the private dispute sort of the private dispute resolution, people that offer dispute resolutions, not within the
Yeah.
the arm of the government. Yeah.
Yes,
So
this is it.
yeah.
This is it. So when you get beyond the Xeon stage,
Yeah.
you could also be directed, for example,
Yeah.
to mediators or neutral evaluators working online.
Yeah.
So you would then choose a mediator using an online directory, and you could then, because this is another element of the pre-court digitisation, that dispute resolution will be placed in the hands of private dispute resolution companies. For example, CEDA, Centre for Effective Dispute Resolution, is one such well-known one. ADR Group is another, and so on. And they would all connect into Xeon. Work would be sent to them. They would then, I'm very keen to emphasise the practicalities. At the moment, in England and Wales, mediation is almost a hobby activity. So you have perhaps a mediator will be busy with maybe 3 cases a week. What I'm talking about when this new system in pre-court, and everybody is required to mediate, for example, or evaluate their cases before issuing proceedings. You're going to have maybe 2 million cases a year.
Whoa.
To get through those, our calculations, disputes e-filing, DEF calculate, you're talking about maybe 500 mediations a day. So you have to have a platform, you have to have a process, but ultimately, whilst AI, we may, when we have the data from mediations, we may have the data to have an AI propose solutions. One will still require a human mediator to suggest solutions, to deal with the nuances, to deal with the non-verbal communication cues. AI can't do that, not yet anyway. It may never be able to do that. And so you need many, many more mediators. So that's why I keep banging on about phasing. You have to introduce this thing in phases, because you can't just produce a mediator like that. You have to train him or her, and then some observations. So I hope that helps.
Oh, thank you so very much. I think we've got 7 minutes, and can we talk about? I think you sort of mentioned this when you highlighted about the the inclusive framework.
Yes.
About the digitally challenged.
Yes. Let's talk about that situation.
So we have 6 minutes to go.
6 minutes on digitally detached.
Yeah.
Right. Well, this is something that is a big issue for civil courts. Everybody must be able to exercise their rights. But what do you do if you can't afford a smartphone? What do you do if you can afford a smartphone, but you're just totally flabbergasted by language, no matter how simple? How do you deal with that? Well, the courts in England and Wales have supported. They put in place some digital support using a company it was called We Are Digital WAD. It's now called We Are Group, and they have physical bricks and mortar centres around England and Wales, but they also have online and telephone support, and that's been in place for some years now. I can't remember, maybe 3 or 4 years, maybe longer. Time flies. So that's what they're doing. That is not cheap either. I recently asked the Ministry of Justice how much that would cost or has cost, and under the Freedom of Information Act, and they very kindly confirmed that for 2024 to 2025, the cost was just over £1.9 million, almost £2 million, in fact, for 1 year. And that includes the fixed costs, but also a variable cost according to the number of users.
Yeah.
And so they're obviously busy. Now, I haven't seen any evaluation yet, how successful they are. Perhaps I should ask the Ministry of Justice for that, because they are saying you should replicate to a degree that kind of support in pre-court. I think it's going to be quite challenging for the private sector with tight profit margins to fund that kind of activity.
Oh, thank you so very much. I think you mentioned, in one of our discussions about how smart banking has taken off, and I mean, we're still going on and on about smart dispute resolution. So,
yeah,
I mean, if people can use smart banking, why can't they, get along with using smart dispute?
Certainly. This is one of the things that Sir Geoffrey Voss, as I mentioned earlier, head of civil justice, has spoken about in a speech, in particular at UCL in May 2024, and also in the public engagement exercise. What he says, because I at the moment am working on the engagement exercise, the DEF response, and so I live with this. I see more of this than I see of my wife. And he says this: the digital justice system is not a new, costly digital infrastructure to resolve everyone's problems. That's what he says there. In May 2024, he said, what we're going to do is create this kind of data standard-led resource. It'll be like open banking. Well, I have to tell you, and if Sir Geoffrey's tuning in, I'll mention to him. And perhaps he knows this, that open banking was a project that arose from the Competition and Markets Authority of the UK and got the biggest 9 banks in the UK by market share, 9 global banks, to fund the development of banking standards. That took 7 years. It cost from their accounts, because they're filed at Companies House, from publicly available accounts, that cost £227 million over 7 years. So that's a big number, right? And I'm not sure, this is my point really about Lyseon. I'm not sure that every individual would be able to create those data standards. If you look at open banking standards, if you look at NHS 111 online, they're all created by creating a single source that people log into or integrate via APIs. It's not everybody creating the same thing, because of course there will be mistakes made. The quality may be different from place to place. So I think there's a really good argument for a tool like Lyseon, but that's what we're trying to achieve at the moment. So I think with this exercise, one has to inject into it the reality of cost and time, and I don't think it is going to be. It's not going to be not costly. It is going to be a costly, whether it's a large one or a small one. There is a cost in time and money, and we have to get through to that.
Data as well, because we of course we need to find out, are the users satisfied? Qualitative and quantitative data. We need funding to do that. To collect data. How do we get users to cooperate?
Absolutely, that's a big issue, as you well know. You've done a lot of empirical work here.
Yeah, I have,
particularly in the US. It is a big problem. DEF has been running since 2015. That's when we went live. We've always tried to gather data, and the trouble is, when you have a dispute and you finish it, bish bash bosh, that's it. It's all gone, and you don't want to then say, "Oh, I've got to fill in a survey." So it's very, very, you just don't do really. So that's our experience. It's very difficult. But you're right; it has to be paid for. So in the two pre-court portals we have in England and Wales at the moment, the claims portal and the official injury claim for low value accidents arising from road traffic
Mr.
accidents.
Tony, we have 1 minute to go, so I might just...
They are paid for by the insurance industry. So who is going to pay the private sector in pre-court? There's 1 minute.
Wow, was awesome. So I'm just gonna we're gonna have a second section, obviously, because we still have more things to touch on. So all right, you take care. See you soon. Cheers.
See you. Bye.